Court of Appeals Division 1 is now in session.
Please be seated. Before we begin, I'd like to welcome the students from the Arizona State School for the Deaf and Blind. They're here to learn how appeals work. Now, we are here in our case 1CA CV22-0710, Wood versus COCONINO County. Each side will have 20 minutes to present their argument, and the appellant, you may reserve as much time as you want for rebuttal, but you'll have to keep track of the time yourself. That's why we have a clock at the podium. We are recording the argument, both audio and visual. So when you begin the argument, please identify yourself. So when we review the recording later, we can keep everybody straight. The argument will be up on YouTube in a day or two, so you'll be able to see how well you think you did. We've read the briefs and conference's case. We've sent you orders about what we're interested in. So when you begin your argument, please just start right into what you want to talk to us about. Counselor, you may begin.
Thank you, Your Honors. My name is Joseph Carver. I'm an attorney with the Coconino County Legal Defender's Office in Flagstaff. It is my privilege to represent Annette Wood, who is the appellant in this matter, as we seek to regain her right to vote. My plan here this morning will be to present the arguments that I have prepared for you today, answer any questions that the court may have to the best of my ability, and then...
Well, a question that I've had is, your client wants to retain the right to vote, but that does not make it unlimited guardianship, does it? As I understand the guardianship statutes, the guardian has certain rights and duties under a general guardianship, and limited guardianship would be some subset of those rights and duties. And voting is a personal right that the guardian can't exercise. So aren't we really talking about a general guardianship as opposed to a limited guardianship?
If I understand the question, Your Honor, are we talking about whether the court should have imposed a general versus a limited guardianship, and given Ms. Wood the opportunity to retain the right to vote? And my response to that, Your Honor, is that under a plain reading of the statutes, voting capacity or voting rights is just not part of the distinction between a general or a limited guardianship. Because as Your Honor pointed out, what a general guardianship and a limited guardianship are about the powers of the guardian, not the rights of the ward. It's about what a guardian can do on behalf of the ward. Voting is our contention, is an entirely different type of decision than the ones that the guardianship statutes address.
Counsel, to that end, I guess, so the remedy, the relief that you've sought is quite broad. What would it look like for us to give direction following this case? What is a way, or how do you purport to protect the right to vote while recognizing that we have a constitutional provision that precludes incapacitated persons, adjudicated incapacitated persons from voting, and there is some realm of individuals who perhaps cannot vote? How do we acknowledge that? What does it look like?
It's true, Your Honor. It's a big request, and we're not shying away from that at all. The simplest way I can put it is what we're asking this court to do is to declare that nobody in Arizona can be disenfranchised under the Arizona Constitution, Article 7, Section 2C, and its enabling statutes. The briefing has outlined, I believe, a structure that the legislature could use if it so chose, if it wants to disenfranchise persons going forward for some reason, that there is a structure that the briefing outlines that could be used, and that this court, in ruling on our appeal, could provide that guidance. It's a difficult ask. It's a big ask. But
Let me ask you this. At the outset, so there is a process for adjudicating an individual as incapacitated. That's the first step in the guardianship or after a petition. But is there a way to reconcile the constitutional provision and at least the spirit of the statutes by incorporating what I would call a pre-deprivation process? Perhaps a pre-deprivation, so as a part of that adjudication process, an evaluation of whether an award has a sufficient understanding to allow for the right to be retained.
Again, if I understand, and I may not understand entirely, but I think that this court does have the authority to look at Article 7 2C and take that phrase, adjudicated incapacitated, and define it in a way that may be, at least on its face, contrary to what the statutes define it as. Because I will say, when I first picked up this case and I started looking at the issues, one of the things that jumped out at me was that it looks like the legislature is defining a constitutional provision. And so I had to kind of get over that hump to analyze the rest of the guardianship statutes. The caution that I would urge, however, is that this court may not be able to, just through definition alone, get us to a point where we have a constitutional pre-deprivation proceeding, because as our briefing indicates or would contend, is that you can't take that right away automatically. It has to be presumptively retained, that there has to be some individual determination, and then there also has to be a standard. And the standard that we're proposing is that a person can communicate with or without accommodations, a specific desire to participate in the voting process.
As to that last standard, do I understand your brief and your argument today to be that is how we should interpret sufficient understanding? In other words, the legislature's test is not itself a problem, it's how we identify what, a sufficient understanding of what. That's part of the problem that I've outlined in the briefing, is that we don't know what sufficient understanding really means. It can change from judge to judge. My question was, is that how you're defining it? That's how I would define it. Standard. I'm sorry, yes. And I guess I was jumping ahead, but I don't think that's sufficient. We can't just put that into 5304.02 as the standard, because there's a problem with the burden of proof as well. Mm-hmm. And so I think...
But your proposed definition involves a desire to vote, which isn't the same as an understanding of the right to vote. How does your proposed definition satisfy the terms that are used in the statute?
Judge, I would just push back just a little bit. I think that a person who expresses a desire to vote shows prima facie an understanding of the voting. Because if you can't tell somebody that's what you want to do, or to flip it, when you tell somebody that you want to do something, in and of itself, that is expressing some understanding of the task, in this case voting, that you want to participate in. And so the problem with a standard or a test that starts with a word like understanding is that opens the door to subjective definitions of who is a worthy voter, Because now we're not talking about whether you can fill out a ballot and mark a choice that you want to mark. We're talking about whether that was a good choice or not. Whether if you understand your civics well enough, would have you made that choice or not? And so that's why I think that the test has to be, it's simple, but it does reveal a lot of information, which is the expressing a desire to participate in the process. And I'd also point out, nobody else in the state of Arizona has to demonstrate a sufficient understanding to exercise the vote. Only persons under guardianship, as it currently stands, have to show some sort of adequate political science knowledge or civics or history. Everyone else is presumed to be able to vote who they want to vote for any reason or no reason at all.
I'm sorry, go ahead.
But are they really similarly situated since they have been adjudicated incapacitated, which makes them different than people who haven't been so adjudicated?
Certainly, persons under guardianship are situated differently, legally speaking. But first, I would say that it's not a relevant distinction for purposes of voting, and we can see that just by looking at who can vote in the state of Arizona. As we pointed out in the briefing, persons who are disabled can vote. People who are mentally ill can vote in the state of Arizona, so long as you don't end up in guardianship proceedings. So the similar class here, if I can just back up, that persons under guardianship aren't dissimilarly situated to a degree that would justify taking their rights away because of the disability, because there are people in Arizona who are disabled who can vote. It's an arbitrary legal classification. When somebody lands in guardianship, suddenly they lose the right to vote, but not through any process that considers that choice in any way.
So this is relating to your equal protection argument. Is there a suspect class that you believe that would trigger strict scrutiny of these statutes?
Yes, Judge, I think that disability under United States Supreme Court case law does qualify as a protected class for purposes of equal protection. I didn't briefly...
What case is that?
I'm sorry, Your Honor, I cannot cite that off the top of my head, I'm sorry. But what I was, in response to Judge Kiley, what I wanted to point out too is that my understanding of the Equal Protection Clause jurisprudence is that on the one hand, you can have a suspect class, or not a suspect class, but a protected class, and Equal Protection Clause applies. But it also applies when you're talking about a fundamental right, and whether a law singles out a class, whether they're protected or not, it singles out a class of persons who cannot access that right. So I think that it's equal protection kind of coming or going, but I focused on the fact that we're talking about voting as a fundamental right, and that Arizona's laws take a class of people and say that right no longer applies.
When you look at the definition of incapacitated as the person lacks sufficient understanding or capacity to make or communicate responsible decisions concerning his person, do you interpret that language as including the right to vote, or not speaking about the right to vote at all? And my question is voting a responsible decision concerning the person?
Thank you, Judge. There are a couple of reasons why I don't think that definition includes voting or should include voting. The reason that it does not include voting or the act of voting is because that Arizona's definition, as it's in the statute of incapacitated, doesn't stand on its own. If you go to the Matter of Reyes case, it has a specific judicial definition now, so that that definition itself avoids unconstitutional or constitutional problems. As interpreted by the Reyes case, adjudicated incapacitated, or the definition of incapacitated, takes out the idea of responsible decision, because that's what makes that definition constitutionally problematic, because now we're talking about responsible to who? Who decides what is responsible? Is it a good decision, or is it just a decision that endangers the person's health? And so if you take Reyes, what incapacitation is really talking about in the guardianship statutes is a person's concrete ability or inability to care for basic necessities, medical care, food, shelter, and clothing, and does not include, therefore, voting.
So if you're under that understanding, then whether you're in a guardianship or not, it doesn't affect your right to vote, except because of it was under the Constitution.
Right. I think that the only effect on the right to vote through an incapacitation determination is the operation of law, that the proceeding itself does not address your ability to vote, to mark a ballot, or tell anybody who it is you would prefer to be the senator or president. It's just not part of the distinction, because I think, I'm speculating, but historically it was just determined that we're not going to allow people under guardianship to vote with no real reasoning as to why that would be the case. As the briefing outlined, it's a discriminatory presumption that has existed for over a century now in the state of Arizona. But our understanding of mental health and our technologies have allowed us to move past those, I guess, benighted presumptions. And I believe that it's time to update Arizona's disenfranchising provisions. So,
Well, if a person is required to have an individualized determination of whether they're competent to vote or not, didn't Ms. Wood get that in this case, because the purpose of the evidentiary hearing was to determine whether she should retain the right to vote. So whether or not the judge was correct, she, as far as the process goes, she got that process. Is that correct?
I would disagree, Your Honor, based on the way that the proceeding below went. If you review the record, it's clear that the trial court was at least interested in, if not more interested in, whether she could impose limited guardianship or not. The court's questions to counsel below were focused on, well, Ms. Woods has these needs. What limitation on the guardian do you think that I can impose so that we can even reach the voting rights question? And then, so a large part, that hearing in Flagstaff was not about Ms. Woods' individual ability to vote. It was about what's the level of guardianship that we can impose in the first instance.
Would you agree, though, that the court reached an alternative holding that even if a limited guardianship was available, Ms. Wood had not demonstrated sufficient understanding? And if you agree with me on that, do you think the court applied the correct test for a sufficient understanding legally?
One, Your Honor, yes, I agree that the court did use the limited guardianship 5304.02 as an alternate holding, but the standards that the court applied were incorrect and inappropriate. And to Judge Howe's point, ultimately meant that she did not get an adequate individualized determination of her right to vote, because, as the court said below, it didn't know what sufficient understanding to exercise a vote means. And then, as I've mentioned also, the burden of proof really hamstrung Ms. Wood's ability to show that she retained an ability to communicate a decision about voting. So while there was a hearing about...
So the problem with the hearing was Ms. Wood had the burden of proof initially, and the burden of proof was too high anyway.
I think that burden of proof was one of two problems. One was that there wasn't a good standard, that the standard was too vague and amorphous, and then you just have this really high, clear and convincing standard to meet a definition that we don't know what meets that definition to begin with. And so that ultimately, at the end of the day, there wasn't a sufficient individualized determination of Ms. Wood's right to vote. And Your Honor, I see I have about 90 seconds left, so I'd like to reserve that for rebuttal.
Surely. Thank you very much. Counsel?
Your Honors, my name is William Ring, and I'm the county attorney in Coconino County. My colleague with me is Heather Mosier. In small counties, the county attorney often takes several roles. So my role today is to argue the position of the public fiduciary. We do not represent the state of Arizona or the legislature's intentions when they devised the statutes that we're attempting to read and interpret. The fiduciary has a different role.
And what caused the public fiduciary to change its position here?
Can you explain the question?
Sure, the public fiduciary took no position initially in this appeal, and now it has.
Well, let me explain that then. The reason the fiduciary has a stake in the outcome of this case is simply that in an instance where a person suffers from some type of mental incapacity, we're not talking about physical incapacities, because when it comes to voting, physical incapacities, the statute allows physical incapacities to be accommodated by another individual who assists the physically disabled person in the act of voting. That's ARS 16547. These are mental incapacities, and realize that the evidence in Ms. Wood case is that she's...
If you could direct your answer, I think what Judge Howe is asking is what came into your knowledge or understanding that changed the position? I understand the sort of broader point that you're getting at, but what changed the public fiduciary's position?
Sure. Ms. Wood suffered from unspecified dementia, behavioral disturbance, severe intellectual disabilities, and cognitive communications deficits. Right? What is the role of the public fiduciary then when it comes to an individual's exercise of the franchise? What role does the fiduciary play? The reason why the fiduciary felt it was necessary to inject an argument about the capacity to vote is to avoid a situation where the public fiduciary actually has to take on a role assisting mentally disabled, as Ms. Wood is. And 40% of the public fiduciary's client base has deficits that look like Ms. Wood, that would avoid the entanglement of the fiduciary in assisting or explaining or describing the ballot in a way that would allow the ward to vote. And let me just explain before we take the next question. There's really two types of questions that are on a ballot. One is, who do I want to represent me? Other questions are direct democracy questions, like an initiative on abortion.
So are you suggesting that the nature of the vote itself, the subject matter of what's on the ballot, drives who can vote?
No, not at all.
I would hope not.
What I'm saying is that the fiduciary should not become entangled in explaining to a person with dementia.
Well, I don't think that anyone is saying that. Ms. Wood, by my reading of the record, knew how you vote, explain how she came to her decision, and the way that she explained it seemed mighty common to what a lot of people do. They watch TV, they talk with their friends. it seems like she knew how to vote, and no matter how complicated the issue might be, she can do that. I mean, do you dispute that the record shows she could do that?
Well, let me comment on the record, and I'll answer your question.
Thank you.
Yes. You realize that this hearing was conducted by Zoom. It took a matter of minutes. It's a thin record. It's simply Ms. Wood with dementia and other related deficits, and that was the subject matter of the hearing.
So are you agreeing with counsel that it was an insufficient hearing?
I'm not agreeing. My point, I would agree with counsel only to the extent that this is not the record to make some broad-based constitutional ruling upon. There's just not enough information. There's insufficient explanation of the wide panoply of disabilities, particularly the co-occurrence of different disabilities, in order to make a pronouncement about the right to vote. The record is...
Because what we're here right now is to adjudicate whether Ms. Wood was improperly denied her right to vote. Whether that has broader implications that may be or not be, but what we're deciding here today is whether Ms. Wood's rights were violated.
Well, Your Honor, if you take a look at that, that's why the portions of the record that are important are that the decision-making process of the trial judge. I mean, the trial judge was there to assess Ms. Wood's capacity or sufficient understanding, but she also had before her the report of a professional and a court-appointed investigator who both concluded that Ms. Wood was suffering from the disabilities that I had mentioned before, and I don't need to repeat them. So in the record of the transcript, it's fairly clear that the judge attempted to evaluate all the evidence. And what she arrived at, the trial judge arrived at, is, as I read the record, a situation where she had just adjudicated a person generally incompetent based upon the evidence that was at hand. And then she's grasping to find what about a general appointment ought to be different in the case where we're talking about the capacity to vote. Because the ruling was that she is generally incapacitated, and in fact, Ms. Wood's attorney conceded that point at the hearing. The only issue in litigation was this retention of the right to vote that you get to through a limited guardianship, which the judge determined was not available because of the degree of Ms. Wood's complications.
Well, counsel, a moment ago you said that there are different types of disabilities, different types of deficits, but the statute doesn't distinguish between any of those, right? The statute says if a general guardianship's appropriate, you lose the right to vote no matter what your specific situation is. Isn't that right?
Well, Judge, I would say it this way. The statute's looking for a sufficient understanding, right? Those words, sufficient understanding, they're elastic.
That's only for a limited guardianship.
In the evaluation process, yes, after having found and determined that Ms. Wood was in need of a general guardianship because she was incapacitated, what then does the trial judge look for that in a sense rehabilitates this person to the capacity to vote? And what they're looking for
So are you
is...
suggesting the judge could rehabilitate her to the right to vote under a general guardianship?
I'm suggesting that the public fiduciary is not a contestant in that question, right? When you think about how that statute is structured, it's the ward, Ms. Wood, who's now asking, after having been generally adjudicated incapacitated and in need of a general guardianship, by clear and convincing evidence, what is there to refute that finding, but only for the purpose of the voting franchise?
I think that, sorry, you go ahead.
Go ahead.
To Judge Kiley's point, the statute does not, as I read it, allow for voting rights for somebody under a general guardianship, which is,
Yes.
I think, Ms. Wood's point, in that there is an automatic deprivation of a fundamental right with no individualized determination when we're talking about the general guardianship.
And isn't that a due process violation if there's no process by which she can prove that she is competent to vote?
Understood and appreciated, but think about the process. I mean, appellant is trying through their petition, and look, they're eloquent, and they've done a good job with their argument. There's no disagreement with the layout that Mr. Carver and the amici have provided. In this particular case, however, think about the process for the trial judge. Think that you are the trial judge. You're there, first of all, to determine whether a guardianship is necessary. And if there is a guardianship, what is the quality and nature of that guardianship? How much power or authority over the ward's affairs is the trial judge going to grant to my client, the public fiduciary? The counsel and the amici are trying to set up two standards.
Counsel, I think where we're going at cross purposes here, and it relates to a question I had for Ms. Wood's counsel, is that the guardianship statutes give rights and duties to the guardian. Voting is not something that can be exercised by the public fiduciary. It is a personal right of the ward.
Yes.
So I guess a question I've been meaning to ask you is, when the court determines that you are incapacitated and a general guardianship is required, does that necessarily include a finding that you're incompetent to vote? Your colleague says that's a question not covered by the statute.
Well, I would. I had written language that would, in a hypothetical order from the trial judge that comments on this very issue, to say something to the effect that the guardian has no ability to impede the ward's exercise of the franchise. Right? And that's enough to satisfy the public fiduciary to say that a guardianship hearing is really about the powers and authorities that you're going to grant to my client, the public fiduciary, or other private guardians. Is it some, all, or none? And if it's less than all, then what shall it be? I think the compromise is that you can do a general guardianship, but say that the guardian's authority does not extend to the power to impede the ward's exercise of the franchise.
But don't I understand that under the statutory scheme, if there is a general guardianship and it is not for physical impairment, that automatically by operation of law, the county recorder is required to remove the individual from the voters' rolls?
Yeah. That's a good point, Judge. I don't know the answer to that. That answer lies in Title 16, and I'm just not sure about that. But I am certain that 16101A6 says that a person who's been adjudicated incompetent loses the right to register to vote. And registration to vote is important because it determines the form of the ballot that will be issued to the voter. And it's based upon your residential address. And as you know in the record in this case, Ms. Wood did not have her physical address available to her at the hearing. And so...
Let me take a step back for a moment and just ask you this. Statutes that deny or substantially restrict a fundamental right are generally reviewed under a strict scrutiny standard. Do you agree that voting is a fundamental right? And if so, do you agree that these statutes should be reviewed under a strict scrutiny standard?
Your Honor, I want to answer the question by starting with the fact that the public fiduciary has no stake in the outcome of the constitutional issue, except to the extent that she becomes entangled in trying to explain to a person with dementia the contours and the characteristics of the items on a ballot. And I explained that before about, the direct democracy questions, like should I vote on a school bond issue, or should I vote yes or no on an abortion initiative. That's the kind of entanglement that my client doesn't want to get into, which is the reason why she's here to change, not to change her position, but to make her position clear. Now,
well, I understand that the public fiduciary doesn't want to influence the ward's decision in voting, but the issue that we have here today is whether she has been unconstitutionally denied her right to vote. So are you saying that the public fiduciary, and by extension the county attorney, doesn't take a position on that issue here?
We do not take a position on that issue. We have read the brief of the Attorney General's office and would leave the argument to the Attorney General. I could, as an officer of the court, offer an answer, but it...
Well, but we run an appeal in an adversarial process where both sides are contesting an issue, and it appears, at least from your explanation, representing the public fiduciary, that you're not taking issue with the issue whether she was denied her right to, improperly denied her right to vote. That's not your concern. Your concern merely is that the public fiduciary should now be entangled with the ward's exercise of her constitutional right.
That is part A. Part B really goes to a point that Mr. Carver made with regard to the burden of proof at a hearing where the petitioner has filed for a limited guardianship in order to preserve the right to vote. You can talk about burden, and burden is an expression of the legislature's intent to take the exercise of the franchise to a level of acuity, mental acuity, to exercise that vote. But at a hearing such as we had, there is, if the public fiduciary takes the position that they took at the hearing, which is we're really not contesting the right to vote or the capacity to vote, which is consistent today. What is the role then of the state at that hearing? You've got a petitioner who's seeking to reestablish the right to vote, and you've got no party in opposition who can argue against that matter. The public fiduciary has no burden of proof. The public fiduciary has no burden of persuasion.
The public fiduciary is the one who petitioned for a general guardianship?
That's true, but we did not petition to sever Ms. Wood's voting rights. That was not
by definition you did then, because a general guardianship, if imposed, automatically severs the right to vote.
No, I would disagree with you. By operation of the Constitution of the state of Arizona, the severance sprung.
Are we just saying that the public fiduciary is just not aware of all the consequences of the petition, or it just doesn't matter?
Well, what would it matter if she did? Would that be a reason not to file the petition? In other words,
what we're saying is at the petition hearing stage, there is a question of who, so let's assume at that adjudication of the initial adjudication hearing regarding the guardianship, that the court would need to, at that stage, evaluate the sufficient understanding standard, whatever we decided that to be. Then wouldn't it be up to the one petitioning to offer evidence on that point?
Not necessarily, and it's not in my client's interest to do so. This would be a petitioner who's asking to establish a civil right, and the public fiduciary has no interest in the severance of that right, but does not want to become entangled in exercising that right. So there's a middle ground here. And in the hearing that was...
We might want to have a middle ground here, but I'm not sure that the statute... Can we interpret the statutes to allow that middle ground? Because by my reading of the guardianship statutes, once a person is declared incapacitated and gets a general guardianship, the right to vote goes away, whether you want it to or not. It does.
Well, agreed, but it's triggered by operation of the Constitution. The petition sets that in process, but that's not a reason for the fiduciary not to file the petition. And the fiduciary is not there to explain and argue the Constitution. The petitioner, the public fiduciary, is there to take care of comfort, care, and to prevent waste. It's a benevolent act of the fiduciary to file the petition to care for a guardian. She has no interest in severing the right. The right is severed because it's triggered by the Constitution. Right? And as to that, that's a determination that takes effect by operation of law. Right? So I am concerned that that argument would lead the fiduciary not to file a petition at all because it results in a deprivation. That's not the right incentive for a public fiduciary's office to incur. Right? I think part of the problem, I see my time is coming to an end, part of the problem is your record. Your record is not complete. You don't have the legislature here to argue the merits or the virtues of why the Constitution is the way it is and why 16101A6 operates the way it does. The Attorney General has filed a response brief. It seems cogent. I don't think on the record you have the question that the petitioner, that the appellant is asking you to decide, because the record is so clear about the mental incapacity of Ms. Wood that when the trial judge got to evaluating the question...
Your time is up, but it sounds like you're taking a position that you said you weren't taking a position on.
We just don't want to become entangled in exercising a ward's right to vote.
Thank you. I understand that point. Thank you for your argument. We appreciate it. Counsel?
Thank you, Your Honor. I just have a few points. The fact that...
My first question is the record sufficient for us to decide this issue?
I believe it is, Judge, because the issue here is what are at bottom is what are the appropriate standards constitutionally. If the court sees an insufficient record or a thin record, it's because the trial court and Ms. Wood's counsel didn't know what the standards were, didn't know what they needed to argue, didn't know that a general guardianship is the end of the voting rights question under Arizona law. And so this isn't because Ms. Wood or her attorney just phoned it in at the hearing, or that the record is so powerful against Ms. Wood's ability to vote. It's because the standards themselves produced this record. And if this court can take it upon itself to articulate definite standards, the records going forward will be easier to read and will be more, will be fuller, is what I would say.
I ask you a question, so we will give you a few seconds if you want to.
I'm sorry. I thought another question was coming. I just wanted to say that to the extent that the Arizona Constitution sets this in motion, I would cite the Supremacy Clause of the United States Constitution. The fact that the public fiduciary doesn't want to become quote-unquote entangled in voting rights is a bad reason to preemptively disenfranchise someone. And Judge, the county attorney in its briefing and its comments today repeatedly refers to this idea that once a judge makes a determination that a general guardianship is appropriate, what else are we going to look for? What else would show that a person has the capacity to vote? And I would say, Judge, it's because of what the vote is. The vote is an expression of political belief. It's an expression of desire. It's an expression of goals. It's not about balancing your checkbook. It's not about paying the mortgage. It's not about getting the groceries. It's about those things that make us a citizen. It's about those things that make us human. That's why it's different. And that's why we're asking this court to take a serious look at the way Arizona statutes disenfranchise disabled persons under guardianship. I appreciate your time. That's all I wanted to say.
Thank you, Counsel. We appreciate both of your arguments. We'll take this matter under advisement and issue a decision in due course. We stand adjourned. Thank you.